I'm Steve Susman, the Executive Director of the Civil Jury Project at NYU School of Law. And this project, just a little history, was started last year as the only academic center in the country that dealt studying why do we have juries in civil cases, why are civil jury trials disappearing, which is undisputed, does it matter, do we really care, and if so, what can be done about it? Those are kind of the questions that this project was set up to explore. And one of the first things that I did when I came up with the idea of creating a center like this, a project like this, was to say the backbone of this has got to be academics around the country, law professors primarily, who have studied the jury system and how it operates and have done empirical research. And of course, it was easy for me to go online and Google jury studies and jury professors, and I got a list, and I think I have now signed up every one of them, there are about 55 in total, as academic advisors to the Civil Jury Project. They're all listed on our website. One of the first people I discovered, because her name appears prominently, is an alumni of this law school, Suja Thomas. And I called her. I first sent her an email and told her what I was doing, and she immediately contacted and said, I'm interested. And then I called Suja and said, would she be an academic advisor? And she was one of the first people that said yes, and she has been immensely helpful to us since the project was kicked off a little over a year ago. Suja is currently a law professor at the University of Illinois College of Law, where she teaches employment discrimination, sports and the law, and civil procedure. She clerked for a federal judge in Chicago and then practiced law at 3 different firms, Cravath, Baldock, and later Weil Godshaw. She has written extensively on the right to jury trial, and for someone who considers themselves primarily a plaintiff's lawyer, her big proposition, which excites me to no end, is that summary judgments are unconstitutional. We will talk about that today. We also have joining us today Burt Neuborne, who is a Norman Dorsen Professor of Civil Liberties here at NYU, as well as the legal director of the Brennan Center for Justice. An alumni of Harvard Law School and one of the nation's foremost civil liberties lawyers, he is the author of 4 books and many scholarly articles on constitutional law and procedure. Over the course of his career, he was director of the ACLU and a member of the New York City Human Rights Commission. So we are going to discuss today Suja's new book, The Missing American Jury. And if you have a few bucks with you, you can stop at the desk outside and pick a copy up on your way. If you have a little time, you could get her to autograph it to you personally. I assure you this is going to be worth a lot of money someday, and will go up much quicker than anything you can buy on the stock market. So pick up one of her books as you exit. It's really good reading, and if you're interested in the subject, it's heavily researched. So there are footnotes giving you all kinds of information. I've been studying this for over a year, and I learned a lot reading her book in the last month or so. The final shout out I want to give for what we're doing here is I want to introduce Professor Sharkey, who is a co-director. Catherine, would you stand up, please, of the Civil Jury Project. Our research fellow, Richard Jolly, who is recently off a Sixth Circuit clerkship, and our administrative assistant, Catherine Villanueva. And Catlin, and if any of you want to learn more about our project or get involved, catch one of them on campus or catch me anywhere on my cell phone. By the way, one of the things we have learned is that the biggest champion for keeping juries alive are people who have actually served on juries. They love the experience. Not so with the people who were summoned and not selected. They hate it. And one of the things we have to do is convince the public and policymakers and consumers of litigation services, dispute resolution services, that there's a distinction between being summoned and not being called, and being summoned and picked and serving and returning a verdict. And those people are willing to talk. We just have to locate them. They are real ambassadors for the viability of the jury. They do their work seriously. The academic studies show that if you serve on a jury, you are much more likely to be a better citizen, a measure whether you're likely to vote even, than if you have not served on a jury. So in an effort to contact those people, we have started a Twitter handle called Jurors Matter, #Jurors Matter. If you want to contact us, you just put @Jurors Matter. Jurors Matter, remember that. And when y'all, during this program, you're free to tweet about it. When you leave the program, you are free to tweet about it. Ask people who have served on jurors to contact us. We want to hear from those people about their experience. So now let's begin with, and I'm going to begin by letting Suja talk about, kind of summarize her book, because I know everyone's not read it, your major thesis of your book, and what your conclusions were, and where we go from there. Suja.
Well, it's a pleasure to be here today. Thank you so much for having me. This is such an important project. I'm glad all of you can hear more about it today. So I want to start a little bit with the historical origin of the jury in the United States. It was based on this incredibly vibrant English jury. So that jury was such that grand juries decided whether cases should proceed, juries decided whether defendants were guilty of crimes, and juries decided whether monetary damages or fines should be awarded. And so as a result of that history, we set up in the Constitution 3 different provisions that provide for jury authority. We have in Article 3, Section 2, that the trial of all crimes except in cases of impeachment shall be by juries. We have in the Fifth Amendment a provision that provides that a person shouldn't be held for a capital or a serious crime unless on a presentment or indictment of a grand jury, except in certain circumstances. And then finally, in the Seventh Amendment, we have a provision that provides that juries should decide civil cases, and it's governed by the common law. And the Supreme Court has actually said that the common law in the Seventh Amendment means the English common law in the late 18th century, which is when the Seventh Amendment was adopted. And so the court has said, hey, when we're looking at the civil jury, we should look at English common law, our history. So we have this incredible history, and we have all these provisions in the Constitution that provide for authority, but juries actually decide very few cases in the United States. And some of the stats are that juries decide less than 1% of civil cases in federal and state court. They decide less than 4% of criminal cases decided in federal and state court. And in many states, we actually don't have grand juries. And so what my book talks about is this phenomena of juries deciding few cases, and when juries decide, their authority is actually taken away, and often in many circumstances. So that's kind of what the book talks about. And just let me give you a couple of examples to give this some context. So the Securities and Exchange Commission sued Mark Cuban in 2013. It's a case that Cuban could have settled. Of course, he has lots of money to settle, but instead he decided to take the case to a jury, and the jury found him not liable. But around that period of time, Congress decided actually to shift cases to the Securities and Exchange Commission to decide itself if it wanted, and so the Securities and Exchange Commission started to shift cases to itself to decide, and what happened is they started to win more often. And in fact, there's a Wall Street Journal series of articles about this that shows the shift of authority, and that juries weren't deciding, and the Securities and Exchange Commission started to win more often. So this is an example of a shift of authority from juries to another part of government. Here's the executive. So you have the executive both as the accuser as well as the decider. Another example, and we're not going to talk much about criminal juries in this forum, but another example is plea bargaining. Plea bargaining occurs in over 90% of our cases. And sometimes it's the case that a case is plea bargained, but the person is actually innocent. And Judge Raidkoff has written about this in the New York Review of Books. And there are many cases that show this, but one of the cases that I like to mention is there's a case, a guy by the name of Brian Banks. He was a football player. He had a full ride scholarship to USC, and a classmate accused him of rape. And the prosecutor came to him and he said, take 5 years in prison if you take a plea, or if you go to a jury, you're going to get 41 years to life. And Banks was like, all right, I've got to take this plea. So he goes to prison, and he comes out, and the person who accused him of rape friends him on Facebook. And then at that point in time, she admitted she had made this up. And so it sometimes happens where someone will actually plead guilty when they're actually innocent because of this disparity between what's available at the plea versus what's available at the jury. So the prosecutor ends up being the decision maker, not the jury. And so this is another example of a shift of authority. And then just the final example I want to give you is remittitor. Remittitor, I actually found out about just down in the Southern District of New York many years ago. It was a case I tried a few years after I was in law school, and we represented a client in a discrimination case, and we ended up getting a great verdict, and it was $219,000, and emotional distress damages was part of the verdict. But the employer said that's too much. A reasonable jury could not find that much. Judge, you should reduce it to $20,000. And the judge did exactly that. The judge said the maximum reasonable jury could find was $20,000. And we ended up selling for more than that, but almost invariably, over 70% of the time, people just take the remitted amount. And so this is, again, an example of a shift of authority from juries to another part of government. Here, juries used to decide damages and not have judges questioning them. So all of these examples are where juries decide less and other parts of government decide instead. And so that's what the book's about. The book is about the shift of authority from juries to other parts of government. What I don't talk about in the book, which is an important topic, is arbitration. I don't talk about arbitration because it's an agreement, and it's not a shift of authority away from juries to another part of government. But in the book, I kind of get at what is going on and why it is the case that juries decide few cases and why the authority of the jury has shifted to other parts of government. And just one final point that I want to make is I kind of compare juries to other parts of government. That is the executive, the legislature, the judiciary, and the states. And if you think about all of those parts of government, they thrive, right? They make laws, they prosecute crimes, but the jury doesn't exist hardly in any way, as I said, from the statistics that you see. But if you look at how the Supreme Court has actually treated the jury as opposed to treated these other parts of government, it's created doctrines like separation of powers to protect the authority of these other parts of government. It's created federalism to protect the authority of the federal government versus the states. But it's actually never created doctrine to protect the authority of the jury. And I think that is a huge part of what's happened to the jury. What you'll see is the Supreme Court actually deciding cases in favor of jury authority, deciding one issue in favor of jury authority, and then over time, over and over and over again, deciding that same issue against jury authority. And that, in sum, is what my book is about, and I'm looking forward to talking more about it.
So, Suja, this idea of you call the other three branches of government constitutional actors in your book. And you say that they're really taking the power away from the jury. And the jury, of course, it's understandable why they can do it, how they can do it, because people serve for judges for almost life, or long time periods of time. There are people that serve in legislative without term limits for a long time. Jurors are there for 5 days, 3 days, maybe once in their lifetime, maybe 2 or 3 times. There's no association of people who have served on jurors. There's no way, and until we began the Civil Jury Project and are encouraging these people to talk to us and speak up and be heard, there was no one in the country that had any interest in even listening to them, what was happening to them, and why they. So they don't have any ability to defend themselves, to fight back, to say, wait, this is a decision that got left to us. Now, it's understandable, I think you point out in your book, that judges, you can understand why judges are taking jurors' power away from the juries. They have been since the 7th Amendment, certainly in the civil case area. Because less power for the jury means more power for the judge, right?
Right.
That's understandable. But why are legislatures, state and federal, what's in it for them why are they limiting the jury's power? What's happening that's causing them to shift power away from juries?
Yeah, so the legislature, as well as the executive, they also sort of have incentives, like, I think judges. Now, judges, it's a complicated question as to why, for example, they order summary judgment. But certainly it does shift authority to them. In terms of the legislature, in terms of the executive, there are lots of incentives for all of these bodies to sort of decide in a certain way. There are potentially election incentives, right? So election incentives get us in legislatures to enact tort reform. We have incentives by the executive for the SEC to decide cases and for Congress to shift those cases to them so that they can win those cases more often. So I think one of the things that's really important to think about the contrast between the jury and these other parts of government is that the jury actually has bias that's screened by other people. The other parts of government actually screen their own bias. The jury doesn't have incentives like these other parts of government, but these other parts of government do have these significant incentives. And so I think all of these things were actually factored in when the founders actually chose the jury and put the jury in these other parts of the Constitution and gave it authority to decide. The jury was never thought of kind of as a perfect body, but Thomas Jefferson kind of talked about that and said, it's the best body to decide, it's not the perfect body.
Burt, so what's wrong with just saying, I think we need to look for the why. Why do policymakers distrust juries today? What's going on? And when did it begin? And how do you square it with the founding fathers? It's clear that they wanted juries because they wanted to protect David from Goliath. That was it, man. It was the anti-federalists, the Southerners, that wanted to protect Main Street from Wall Street, debtors from their creditors. And it's clear in the discussion of the debate about the adoption of the 7th Amendment. And, they didn't care whether juries were wowed by lawyers or accurate or it was inefficient or took more time. None of that bothered them. It was to them the ultimate protection of the average citizen against an overreaching central government, corrupt executive who hired corrupt judges. So why don't we just acknowledge it and go on?
Well, okay. That's a nice unbiased question. It's always good to have a moderator who's in the middle. Let's start for a second. I don't think we can talk about the jury as a single institution. You have a civil jury and a criminal jury. The criminal jury formally stands between the individual and prison. And I think the criminal jury, you can build a very strong case for the fact that it is an enormously important institutional check, And for example, the concerns that, by the way, let me start by saying Suja's book is wonderful. And if you do get a chance to buy it and read it, you should. It's a terrific introduction to the jury system, and it's full of insight and wonderful things to learn. Now, having said that, and I don't disagree with a great deal of that's in the book, but in terms of thinking about it, I like to start by thinking about the criminal jury first, and the role of the criminal jury, because the criminal jury is the government versus the individual. The civil jury is usually one individual against another individual, with the jury as the fact finder. But I want to start even further back than that. Well, and so as you might expect, the rules are different. Can't direct a verdict of guilt in a criminal case. There is no summary judgment. There is no NOV. Because double jeopardy would prevent it. We still treat the criminal jury as a very serious institution. The sentencing guidelines were declared unconstitutional in large part because Justice Scalia dug in and said that they erode the role of the jury in a crucially important place. The guilt beyond a reasonable doubt standard as a due process norm was a reinforcement of the jury's ability to reject. And the fact that we still, whether we talk about it or not, have jury nullification in the system in criminal cases is evidence of the enduring enormous power that the criminal jury exerts. Now, what Suja points out is that so few cases actually get to a criminal jury because of the coercive plea bargaining techniques that have been injected into the system, and principally by allowing the prosecutor to choose what to charge, and then to have sentencing guidelines that kick in from that, which prevent the judge from controlling or having any significant role in the sentencing, although that's now lessened because the guidelines are precatory. But it is the plea bargaining process, clearly, that is, I think, adversely affecting the criminal jury. But let me start by saying it's only recently that I think the criminal jury was worth saving. Steve and I have practiced long enough so that we practiced in eras when criminal juries were all white men, usually of property. And they did not fulfill the founder's great role. For a long time, they were a slice of the community. Women didn't serve on them. I tried cases throughout the South as a young lawyer, and I spent most of my time scheming to try to get a single black person on a jury. And so it's only in the last 20, 25 years that the criminal jury really is at least arguably a cross-section of the community, and therefore can fulfill its moral role. So that's one thing. That's the criminal jury. I don't think the criminal jury is in crisis. I think that there are the rules that are set up around the criminal jury that prevent directed verdicts, that struck down the sentencing guidelines, are very protective of the institution. And what we have to do as lawyers who care about the criminal jury is think about the plea bargaining system. And to, if we can work out a way to make the plea bargaining system less coercive, then if defendants opt out of juries because they want to, then the jury will have played its role, because the plea bargaining goes on in the shadow of the jury. The prosecutor knows that eventually they'll have to try the case to the jury. The defense knows that eventually the case will go to the jury. And if there's a fair, level playing field for the negotiation of the plea bargain, the system will work. Even if you don't have a radical increase in jury trials, what you will have is a fairer bargaining in the shadow of the criminal jury. But now let's move over to the civil, which is the basic structure of Suja's book, and I think your basic concern, and that's the erosion of the civil jury. I want to say something that may sound quite radical. The good old days, the common law, the English common law, it wasn't so friendly to the jury. There were directed verdicts then. There was summary judgment in merry old England. There was even non obstante verdicto. So that the rules that we have now that we think is so corrosive and of the jury existed at British common law. I don't think they're new. I think what is new is the willingness of the courts to take cases away from jurors, civil juries, and the question is why? Why don't they trust? Why don't judges trust civil juries anymore? Why don't legislators trust civil juries? In part, it's because the story Steve tells. In part, maybe it's an urban myth, but the urban myth is that juries are defendant-oriented in criminal cases and plaintiff-oriented in civil cases. That's the myth. And it's against that myth that a lot of these rules got made. I think the reason that we've seen such a huge increase in techniques to take cases away from civil juries is that there is a basic mistrust of ordinary people to be able to carry out the power that exists in a jury. And if we're interested in dealing with that, it isn't enough just to try to deal with the rules. We have to go right at why. What is it that makes people nervous about jurors? Part of it may be that now the jury is really a cross-section of the community, and they don't want to give the power to a cross-section of the community. They liked it when it was being done by a small elite group, but now when it's being done by everybody, they're getting nervous. For me, think about this. There are only 3 times in the life of a democracy when an ordinary citizen exercises power, not authorizes somebody else to exercise the power, as in a representative democracy, but exercises the power herself 3 times: when you vote, when you serve in the military, and when you serve on the jury. Those are the 3 times that citizens in a democracy actually wear the mantle of government. They actually carry out government power. We, I think, who care about the jury, have to start asking ourselves, have there been examples of jury failure? What are the examples of jury failure that have led to a belief by judges and by legislators? I like to think it's not just a cynical belief, that they aren't just shutting the jury down because they believe the urban myth and want to help the prosecution when in a criminal context and the defense in a civil context. There may be some of that, but I don't think that's the thing. There is something unsettling about giving that much power to ordinary people. And you wonder how, in a country that is going to give the kind of power that we're going to give to the country on Tuesday to select a president, why is it that we're afraid to give that same power to 6 or 12 people in a jury? I wonder, you've had enormous experience with juries. What's your sense of that? I mean, why? Why don't they trust them?
I'm a moderator. I could go on that.
Yeah, but I'm a law
for
professor.
About 45 minutes. But I'm not. I want to stop. We'll get back to it.
Yeah.
Let me go. You made a point that I want to pass up. Suja says that summary judgments are unconstitutional. You say bull. At the time the Seventh Amendment was passed, judges granted summary judgment over Mary England. I think I heard you right.
Yeah.
Okay. Now, someone is right and someone's wrong. Okay. You or Suja, because you can't. If the Seventh Amendment is written in terms that preserves the right to a jury trial, right, Suja? You don't. It doesn't expand it. You get what existed at common law in 1791. Period. Now, Burt is saying, well, judges had the power to grant summary judgment then. Your whole premise of summary judgments being unconstitutional, I suggest, is destroyed if he's right. Now, he's not right, is he?
It's not right.
Tell him why. Tell him why.
So let me just start by, so I'm sure everyone here is familiar, so we're talking about Rule 56, and so there's no genuine dispute of material fact, and the moving party is entitled to judgment as a matter of law. And so that rule has been interpreted by the Supreme Court to mean that you can say a reasonable jury could not find for the non-moving party. Okay, so that's what we're interpreting. And so the question is, okay, is that constitutional under the 7th Amendment? And as Steve said, if the procedure existed in England in the late 18th century, because the Supreme Court has actually said that's what governs, then it's constitutional. But with all respect to Professor Neuborne, it did not exist. And I have to say more than that, because otherwise it's going to be he said, she said. But I wish Professor Nelson was here because he actually responded. And if you're interested, you should take a look at this in the Iowa Law Review. He responded to my argument. And he actually said, yeah, there was no procedure like this. And Jim Oldham at Georgetown, who I think was here for the patent panel, he also has said there was no procedure like this in England in the late 18th century. The only procedure that existed prior to trial that you could use was called the demurrer of the pleadings. And under the demurrer of the pleadings, you actually had to accept the facts as true. The defendant, if the defendant accepted the facts as true and there was a claim, the defendant actually lost. And if the defendant accepted the facts as true and there wasn't a claim, the defendant won. But that was it. In terms of sufficiency of the evidence, which is what the question is for summary judgment, that type of question actually only happened after a jury trial. And so after a jury trial, a judge could decide whether the evidence was sufficient, and the judge actually had to order a new trial. That's all the judge could do. And if the judge disagreed with the second jury, the judge would actually never really order a third trial. The judge would just, that would be it. So a judge would never be able to question a verdict after trial, never be able to determine what a jury could decide before trial. That was the system that we had back in England in the late 18th century, and that's why I argue that summary judgment is unconstitutional.
Let me respond on behalf of 76 of the 77 Supreme Court justices who passed on this since the Civil War. You're of course right that there was nothing called summary judgment, and there was nothing where prior to the jury trial you could cut the jury trial short and have the judge say, look, the evidence is not sufficient and there's no possible way that a verdict can be returned. It's true under common law that you had to sit through a meaningless jury trial during which the evidence that the judge has already said in his mind is insufficient to satisfy a verdict is tried to the jury. And the jury says, we want a verdict. And the rule at common law was, the judge says, you can't have one. It doesn't strike me as being some huge radical interference with the institution to rotate that process forward.
Hey, wait a second, don't go too fast. I think Suja says in her book that if you, in merry old England, when you sat through a trial and the judge said, there's not enough, a reasonable juror couldn't find this, that the only remedy was to grant a new trial.
Right.
Not to throw the plaintiff out of court forever and ever.
Okay, so
that's a big difference.
So the question now is two changes in British procedure, and whether or not this is enough to render the practice unconstitutional. The first change is that the event takes place before the trial, before the jury hears the evidence, rather than after. With the parties being encouraged to tell the judge, this is what we're going to present, and the judge saying, that's not going to be enough. And since it's not going to be enough, I'm not going to waste the juror's time, and I'm not going to waste the court's time in a proceeding that I am going to set aside. The second, so that's, there I think there isn't even a conceivable argument that there's a violation of the Constitution. Because all that's happening is that you're taking one procedure and instead of having it be exceptionally wasteful and ultimately disrespectful of the jury, because the jury says something and the judge slaps them, and just rotating it forward and saying, let's do it now and not waste time. That I think there can't, for me at least, I don't see the shadow of a constitutional argument. The constitutional argument has to rest on the fact that what the judge could, the only thing the judge could do there is to rotate back and have a new trial, and can't dismiss the case, but can have a new trial. And is that a sufficient difference from the practice? When the new trial, I mean, I know that Suja says, as a matter of practice, the judge often didn't require that to happen a second or a third or a fourth time. Well, there's nothing in British law that forbade that. It was just a sort of practice.
Yeah, so can I just, a couple things to respond? So one, I have to respond to the idea of the justices. So I have to throw this out there that on my wall, I have a letter from Justice Scalia. Now, I know Justice Scalia has passed, but he said, your article is persuasive, and I wouldn't doubt it if you got it wrong, but I'm not sure we can do anything about it. And so I at least had one person on the Supreme Court that was interested in the idea.
The other one is a pretty good guy. The other one was Justice Black.
Yeah, right. But then I also want to go to another point, which is about the Supreme Court and how it's actually decided this issue. So initially, in terms of just judgment as a matter of law, which is the analogy, right, to summary judgment after trial, in 1913, the Supreme Court said if a jury finds for party A and the judge thinks that the evidence is insufficient, the judge can't find for party B, the judge can order a new trial. But just 20 years later, the Supreme Court said if the jury finds for party A and the judge thinks the evidence is insufficient, the judge can find for party B. It just flipped it just changed its mind, and it's done that over and over and over again with respect to jury authority, and that's why we don't have much authority in the jury, because there's been this shift and there's been this grab for power.
So,
Burt,
by the way,
a question about British historical practice. Was it just a kind of exhaustion and inertia that had the judge stop at the second jury, or were they legally prohibited from going to a third or a fourth?
No, they weren't legally prohibited,
Yeah,
but they just thought, you know, if the second jury thought this, I'm not going to go to a third jury.
Well, okay, but that's what I thought. I mean, so the real question is whether or not, I mean, this is in some sense angels on the head of a pin on originalism. Are we going to be stuck in asking what the originalist 1791 position is? So the originalist 1791 position is you have a law that says that a judge can set aside a jury as many times as the judge wants, consecutively over time, until the jury gets exhausted. Now, the judge can get exhausted first and decide he's not going to do it anymore. But the British practice allowed repetitive and consecutive post-jury set-asides of the verdict. Is it so crazy to say that if you take that practice into the 20th century, that the practice that you should have under those circumstances is not an eternity of setting aside jury verdicts, so that the case is a kind of Flying Dutchman that just goes out there forever with jury verdicts being returned and overturned, returned and overturned, and say, let's rotate it back before the jury acts and have the judge pass on the question once. Is that so crazy?
let's put the Constitution aside for a moment. It is clear when you look at the trend lines that jury trials multiplied in this country between 1962 and 1986 shot up in a straight line. In 1986, something happened. In 1962, the average federal judge was trying 22 civil cases a year. Last year, the average federal judge in this country tried 4 civil cases. 3 jury cases, 1 bench case. And that overstates their productivity because there were a lot of senior judges trying cases and magistrate judges that are not counted in the denominator. There are a lot of judges that Obama appointed 2 or 3 years ago that have not tried a case yet. I was discovering that and meeting them around the country. So, but something clearly happened, Burt and Suja, in the mid-'80s. when I looked at what it was, and of course that ties, 86 was the year of the Supreme Court trilogy on the summary judgment. It's one thing to have summary judgments, which we've always had, or since a long time. It's another thing to make it so easy to get, which the Supreme Court did in 3 cases in 1986, that now it's malpractice if a defendant doesn't move for summary judgment in every civil case. So every civil case, you got to go through the summary judgment because the defendant it's so likely that they're going to get it. But then the question is, well, what happened that caused the Supreme Court to rule that way in 1986? Turns out that was the same year that the American Association Against Lawsuit Abuse was established. 1980 was when President Reagan was elected. We began talking about trial lawyers being evil and about lawsuits being bad and litigation horrible for the country. And I suggest that for the last 30 years we've been on this roll. The business community, the business roundtable, has indoctrinated the public, and particularly the judiciary, to think that, you know, if I have to try a case, I'm a failure. Lawsuits, the way to handle cases or efficiently is to dispose of them, grant summary judgment. And we have created this, if you tell the average person on the street, what word do you associate with frivolous, they're going to say lawsuit. Okay? I mean, that's a mind. People have had their minds been, you know, brainwashed on this subject by the Business Roundtable in the Chamber of Commerce. And it's reflected in every decision. It's reflected in every legislative. You read about securities reform in the mid-90s, the new Securities Act, antitrust reform, tort reform, medical malpractice reform, class action reform. Now they're talking about patent reform. It all means one thing. Make sure that it is very, very difficult for a plaintiff who thinks he's been victimized to get to trial before a jury against a big company. Make sure it's really tough for them to do that. And it's got to go through all these screens with judges having the ability to stop it at any point. Pleading, if you don't plead plausibly, out of here. Summary judgment, if I don't believe you have a plausible case, out of here. If I don't think that your expert is reliable, I grant a motion and throw Dalbert the expert. So you don't have an expert. It's all, the judges are controlling this. They don't want, and so we got to think, so I do think that this whole reform movement and what changed people's mind and changed, judges are telling me around the country now that they are shocked that the insurance companies want juries. And the judges all say that they would have been more generous to plaintiffs in cases than the juries were. I mean, so it's kind of a whole shift of the mindset of Americans. But let's put aside the Constitution. Let's ask this, because Suja, your book, and one of your chapters of your book, you have studied all the systems in the world that have kind of like a jury or something similar to a jury. And her conclusion is basically that we are the only country in the world that guarantees a jury in a civil case. Period. Right? And so the question I have for the two of you is, putting the Constitution aside, forget about it for a second, what about our country is different from other democracies that juries are better to resolve civil disputes here than judges or panels of judges or the way it's handled wherever else in the world? What are your ideas about that, Suja?
Yeah, just a couple of comments just on other countries. I think one of the things that was most interesting about writing the book is I did look at about 10 countries and what they were doing. And certainly England has some very small set of civil cases decided by juries at this point, a much bigger set of criminal cases decided by juries. But some of the other countries, in Taiwan, I spoke to a group of Taiwanese judges recently, and they're starting to develop a jury there. There are a number of places in the world where there's a movement towards lay participation. So that's one point. And another point is that even in some places, like France, for example, there's actually, you could argue, more vibrant lay participation in some ways. So in France, they actually have lay participation with judges, and on appeal, they even have lay participation, and they have lay participation in sentencing as well. And of course, that's in all in criminal cases, it's not in civil cases. So I think it's really important for us as a country to kind of take notice of what's going on elsewhere, and that is there's a growth of lay participation while our system sort of, is disappearing, or has disappeared. So that's one thing. And then the second thing is just in terms of who should decide. I think there are studies that show that judges and juries generally agree. Calvin Zeisel, a very famous study from the 60s, showed that they generally agree. And then we know that judges and juries are subject to some of the same problems. They have trouble ignoring inadmissible evidence, and they go towards irrelevant figures, which is called anchoring. So we know judges and juries are subject to some of the same problems, but juries are more diverse. And if we value diversity, we should value juries. And we also know what I spoke about before, that jurors are screened by other people, whereas we don't have that same function with respect to the executive, the legislature, and the judiciary, and jurors just don't have the same incentives. And so because of this, I think there's really good reasons that our country has picked jurors to decide, and unfortunately, we haven't abided by the Constitution.
Burt?
Well,
Why should we have,
I want to just add one more reason why civil juries are collapsing. It's not just the summary judgment rules and the pleading rules and the directed verdict rules and the non obstante verdicto rules. I mean, all the ways that judges can take power away from jurors. It's also the rise of an idea of the managerial judge, that the ideology of being a good trial judge changed at just about the point in time that you're talking about, the mid-'80s. Prior to the mid-'80s, I think good trial judges saw themselves as referees, and their job was to maintain a level playing field, convene the jury, make sure that that it heard admissible evidence, and assuming that the facts were sufficiently at issue and that a reasonable jury could find it, to just get out of the way and let the jury do its job. That it has alleged to be, I don't know the fact, that was alleged to be a very expensive system, a very resource-intensive system that took a lot of time, energy, and money to run, entirely apart from whether it was a biased system, whether it tilted toward the plaintiff or tilted toward the defendant. I think the stories of bias are really urban myths. I mean, I think if one looked empirically at what juries do, they're not tilted that way. But they are expensive. They are very expensive to run. And as part of this big efficiency push, you began to get judges reconceptualizing themselves as, how can I move the largest number of cases? That was about the time where Congress required judges to essentially keep timesheets. Not formal timesheets, but they had to report what they were doing, how many cases they had, how long the cases were open, the material was circulated. There was tremendous pressure put on them to become more efficient. And so they began to view themselves not as referees, but as managers of the case. And that their job was to work out a way where the parties would settle it. And settlement rates went through the roof at about that point. And so it's not just the fact that they're throwing the cases out that explains why they're not reaching the jury. It's because so many cases settle on the way. It's the civil analog to plea bargaining.
So guys, I'm a 12-year-old, my grandson. I'm asking you two lawyers to tell me, and don't mention the Constitution, why should we have civil disputes in this country resolved by juries?
Because we trust individuals and we don't trust the government. That's why. Because we trust the individual and we mistrust the government. And so if I'm going to have,
Professor, a judge is an individual.
No, but he's a government official. Who pays his salary? He is a government official.
Okay.
The huge, what's so unique about our system is the degree of power we give to ordinary people off the streets.
Okay. That's a good point. So you can't rig a jury. You can rig a judge, and you can't rig a jury because you don't know who they're going to be when they show up. That's a good point. And with all this concern about the system being rigged, it does pay to talk about, well, juries protect you against a rigged system. Whether they're trying to shut you up because you said something that allegedly libels someone, protect your First Amendment rights, or protect you, whatever it is, juries protect you. What else?
I think you could add to that.
Tell me
it's,
what else.
Yeah, I think it's really important that the community actually be involved regularly in decision-making. I think that's to be involved regularly in decision-making. And so the community actually being involved on a daily basis in our courtrooms, as opposed to that very rarely do we vote, very rarely are we otherwise involved in government. And so I think it's actually, one of the things you can tell your grandson is that, it's important for us as individuals to actually be involved in government and decide these important questions.
Sorry, that doesn't help me very much.
How about this?
I'm a lawyer, and I'm studying juries.
How about this?
I have no idea what juries are doing in courthouses around this country today.
Yeah.
And no one else in this room does, okay? We don't know what's going on in the Southern District in a jury room with verdicts being returned and who they're being returned for and why they're being returned. So that doesn't move me. How about how about the idea that you get better decisions? Jurors, 12 people are more from different walks of life are more likely to be good judges of credibility of witnesses. In almost every case, you have to find a witness credible or not. Credibility of lawyers who are arguing the case. I think if we're going to save the juries, we need to focus on characteristics of group decision making that make it more accurate.
Well, but
fairer.
that can be, if you want to protect the jury, there's a strong counter story there that's not very good. And that's that when you have a jury pulled randomly from the society, from the community, yes, you do get different viewpoints, but you also get the real risk of irrationality, you get the real risk of bias and prejudice, you get the real risk of someone who carries a grudge against some portion of society, exercising significant government power. I think the reason why some thoughtful people think it's a good idea to take cases away from juries, and I disagree with them, but I think the reason they think so is they think they are moving into a system of reason, where rationality and careful, measured thought controls the outcome, and not where bursts of passion and irrational behavior can play a major role in the outcome. Now, I think they're wrong, but I think that if you're going to defend the jury, we've got to deal with that.
My answer to you would be, hell, I've seen judges who are more biased or prejudiced. Single judges scare me more than 12 jurors. Look at 12 Angry Men, go watch it again, Burt. There were people that came in that room that were angry, that were biased as hell.
Steve, I hate to tell you this. 12 Angry Men is fiction.
Well, now you and I disagree. I think, you could be right.
No, I don't
I
mean
think
it's.
that
I don't mean
happens
it never happens. I just meant that it was literally fiction. I've tried many cases to juries, and I have huge respect for juries. I think the jury is a remarkable institution, and it's a tragedy that it's falling off the table. But if we're going to try to defend it, we have to acknowledge what its weaknesses are, and at least fight back by either developing empirical data to show that it's not true, that that jury verdicts are not irrational verdicts that swing one way or another, and the material that you point out of the agreement factor between judges and juries on cases is very important. And I think we also have to stress the fact that the modern jury is not the old jury, which was not a representative jury. The modern jury is a representative jury. and well chosen, it really does speak for the community. And to have the community play a major role in the administration of law is a phenomenal achievement for a society, and that's what we're trying for. And that's why, I think that's why we have juries. And that's why we should defend them and try to protect them. So, I mean, we don't disagree. It's just that I think if we just parade all the good sides of juries without acknowledging what the darker side of a jury can be. You know, I worked in the South as a civil rights lawyer for a long time, at the beginning of my career. I cannot tell you how many of my friends and colleagues were either murdered or seriously beaten and never avenged in a court of justice because Southern juries would not convict. Because racism so infected that jury process. Now, if you had asked me, as a young lawyer working in Mississippi in 1963 or 1964, did I think the jury system was worth preserving, I would say, get rid of it and put a judge in there that'll convict the person that murdered Valerie Liuzzo. We never did get a conviction in that case. Everybody knew who it was, but the juries wouldn't convict. And so the question is, how do we, one, protect against that? How do we acknowledge that juries can be irrational and still make the argument that they're so important that we can't let them be pushed off the table?
So how do you answer yourself? I mean, how do you answer the argument that there was a time in the South that people who had committed crimes got off because you had a jury that was not a cross-section of the community, and there were miscarriages of justice? How do we, is that just something, you know, we gotta put up with? It's better to let, you know, what is it, one guilty person go free than wrongly convict 100? Is it something we just have to say that too will pass and keep the jury system, because overall it works, particularly if you get a cross-section of the community?
Yeah. So I think that...
And maybe that's the answer. That was not the jury system that was not the jury system that our constitutional founders
Thought about. Well, and no system, as you point out, is perfect. There will be an aberration all the time. There's going to be a biased judge. There could be a terribly biased jury.
Yes.
Question is, in gross, how likely is the problem going to occur? And you're suggesting it'll occur far less often in a jury than it will in a single person.
And I think that's an important point. I think what Professor Neuborne points out is a really important phenomenon from the past about what juries were and who wanted juries. And I think that it's really difficult as a person who studies the Constitution to sort of deal with that fact. But at the end of the day, I am going to go with the Constitution, and I'm going to go with that this body is supposed to decide these issues. And if we need to, sort of in terms of selection of jurors, if we need to sort of improve our selection of jurors, which I think we do, then so be it. But at the end of the day, I get that happened in the past.
Well, you know, of course, the way we worked around it was to create a workaround that creates its own constitutional problem, and that's to really cut back on double jeopardy, so that a state acquittal in a situation like that was often followed by a federal retrial under a technically different crime, and the Supreme Court winked and said, it's double jeopardy doesn't apply. And so they really sort of tortured the double jeopardy rule in order to be able to provide a second forum in many of these cases. And that's one way to do it. One way to do it is to have a
All right, let me give you both inconvenient fact for me, and we'll see how you respond to this. When I came up with the idea of doing this project, calling it the Civil Jury Project, I was concerned about the decline in civil juries. I did not know at the time, and only learned after I got into it, that non-jury trials have decreased at a faster rate than jury trials. Okay?
Yeah.
Now, all this stuff about juries being undependable, juries costing too much money, being too expensive, too time-consuming, that kind of, how do you you know, those arguments, so how about what explains the disappearance of bench trial?
Of
Now,
adjudication.
managerial judging is one explanation, okay? For sure. But how do you square those two? I mean, I would have called it the Civil Trial Center, or the Civil Trial Project, not the Civil Jury Project, had I known what the real problem was. All trials, public dispute resolution is disappearing in this country.
Yeah. So we have obviously the problem of summary judgment. We have the problem of arbitration, which we haven't had a chance to talk about much today. And then we have settlement. And I don't think that settlement's a problem. I do think that more cases will be tried if we do things like what Steve's suggested, which is to have faster trials and do a lot of what we can do by agreement. He has this site called Trial by Agreement that you all should look at. But, so I think all of those things are contributing to even not having bench trials.
Well, I mean, Steve, the point you make, Steve, is so important that this is not a jury problem. It's partially a jury problem.
Partially.
But we used to be a country in which disputes were adjudicated. Now we're a country in which disputes are either thrown out at an early stage before anybody really looks hard at them, or settled. But adjudication seems to have literally fallen off the table. And for you guys who are going to practice in this area, in this world, it's very different from what you think lawyers do.
You know, you're right. Had the result, it's not just a jury, had the result in the hot coffee case, you know, the case about McDonald's coffee case, had that been a judge trial rather than a jury trial,
You never would have heard about it.
we would never even be talking about it, right? That result is because a jury was responsible for that result. That became a poster child of the tort reform movement. Let me open it up to question now. Before we end, we have 11 minutes, and if anyone in the audience wants to ask a question, you have to raise your hand so you can speak into a mic, because this is being recorded, and I think it's being broadcast worldwide right now. Please stand up so you can be heard. Any questions? Yes, sir. Here comes the mic.
Thank you for an excellent presentation. One thing that's been alluded to but not really discussed at length is the incorporation of the adjudication process into the administrative state. To what degree is that responsible for this decline in adjudications generally? Are there statistics on this? Because it seems to me that that is an incredibly important and growing problem, that judge, jury, and executioner are all the same person.
It's a great question. The Supreme Court made a deal with the devil in 1932. In 1932, when the administrative state was beginning to come into being, there were a series of challenges to administrative determinations of important facts. And the challenge was that it usurped the role of the jury. And the Supreme Court decisions in those cases were to say, look, we can live with the administrative state, but this is the deal. From now on, the judges get control of the law, and the administrative agencies get control of the fact-finding. And on review, we will not really review the facts in any kind of significant way, but we will review the law de novo. That case was wrong on the day it was decided, and that's what started putting the nail in the jury's coffin. Prior to 1932, everything that was done by an administrative agency today would probably have been heard before a jury. And now that's a massive shift in power to the administrative state. And you know, to his credit, there were only two justices in recent times, I think, who I've noticed really seemed to care about that. One was Scalia and the other one was Rehnquist. Everybody else perfectly happy with that deal. I think it's a terrible deal.
Other questions? Over here. There's one.
I have one criminal and one civil question that are related. Glenn Harlan Reynolds has suggested that one solution to the plea bargaining problem would be to let people bring it to the jury and say, well, the prosecutor was willing to give me 4 months, now he wants 40 years. You know, surely what he wants now is unreasonable. Other people have said, you know, in civil cases, there should be caps on
I don't quite understand that. You mean after a reversal?
No, the idea was that if you had a plea bargaining discussion and it fell through,
Oh, it
that,
fell through.
that you
I'm
could
sorry.
then bring that to the jury's attention. Likewise, it seems, based, Professor Neuborne, on what you were saying, that maybe if there were caps on damages, there wouldn't be such a concern in civil cases with runaway juries. Do you think either of these or any other ideas out there might rein in some of the problems and therefore bring the jury back into the question more?
So on the plea idea, I actually, in the last chapter of my book, I actually talk a little bit. It's a very short chapter, and I'm actually writing another piece about this, but I actually call it, my idea is the plea offer and sentence requirement, and that is that if a prosecutor actually offers a plea, then when it actually, if the defendant doesn't take the plea, that at trial, it could be one of a number of circumstances, but at trial you would actually receive that information about the charge, but as well about the sentence. And it was the case back in England in the late 18th century, jurors could engage in what was called pious perjury. And they could consider the sentence and actually convict based on the sentence. And so I actually think that that's sort of my, it's my dream to have this come into play, but I actually think that it makes it a fairer system because you don't feel as compelled to take the plea.
My own sense is that we've edged very close to that system now. Once the sentencing guidelines were precatory, if you plead to something, and at that point the prosecution no longer has control over what the sentence will be, because if it's not a mandatory guideline and it's only a precatory guideline, the real question we should be asking is how much influence should the guideline be exercising on the judge at all? Currently, I think they exercise too much influence as a kind of baseline and peer review type of thing. The judges don't want to deviate from that. They think they're supposed to go with it. My own sense is it should be really, truly precatory. If we made it precatory, we'd return the sentencing power to the judge, and the judge would then decide what the appropriate sentence would be, and the plea bargain, I think, would not then be as controlled by the prosecutor.
Thank you guys so much for coming today. I just have a quick question, and it dovetails off that on a way to solve the problem. I've heard people talk about professional juries, and I was thinking about how that might solve the problem of not having a group that's like consistent, that has agency, and also might deal with people worried about their lack of education on certain issues. But you also brought up the idea that there's very limited opportunities for society at whole to like engage directly. So perhaps professional juries would cut off that avenue. I was wondering how you would balance those different things, or if there are other issues with professional juries that maybe I'm unaware of.
I think it's a really interesting question. In a lot of other countries, you have these panels that include judges and lay participation. And I will say, if I was going to create a new system, I might create a system that included judges and more lay participation than you actually had in terms of judges. But I think some countries would probably say that's somewhat problematic because judges actually exercise sort of too much influence over the lay participation. So I'm not sure if that's the best system. But there's also some good work by Jim Oldham on special juries. They used to have special juries back in England, and sometimes you could have a group of merchants kind of decide an issue, and people actually had a right to a special jury. And so as a result of that, he's actually argued that there should be a complexity exception to the Seventh Amendment. I'm not in favor of that. I still think that based on what the history is, that we should have regular people sort of decide these cases. I think that we can inform them of what's going on in harder cases, like through better instructions and through better expert testimony. But I don't think it's the best idea to have groups of professionals.
Yeah, I think elite juries defeats the whole reason why you have juries. I mean, there used to be something in New York called the Blue Ribbon Jury, and I worked for years to have it declared unconstitutional, and I'm glad we finally did. On the other hand, your mechanism comes very close to describing some of the best designed private arbitration mechanisms. International arbitration now often occurs before 3 or 4 or sometimes 5 highly experienced people in the particular field. And so you're actually getting a professional jury, but it's a privately agreed upon professional jury.
So I want to end now by thanking our panelists for coming and talking. There's a lot to talk about, and I do recommend you get her book. She hadn't even talked today. I ran out of time to ask her about her solutions. At the end of the book, she has 4 solutions. A reasoning requirement, a concurrence requirement. Buy the book to find out what they are, 'cause she is promising that she's going to research these 4 solutions, and we're going to have her back next year to tell us what she comes up with on these 4 solutions. So you got to read it in the book. Thank you both professors for being here, and thank you all for coming.